I bought the cabin for one reason: peace. No neighbors pressed up against my fence. No matching mailboxes. No monthly dues. Just a 70-year-old cedar cabin tucked into the edge of the forest, sitting on land that had been surveyed, titled, and recorded decades before the surrounding subdivision even existed. I triple-checked that detail before closing. The listing was clear. The county records were clearer. Not part of any HOA. For the first 6 months, life was exactly what I paid for. I restored the porch, replaced rotting beams, rebuilt the stone chimney by hand. The locals waved when they drove by on the county road. No issues. No letters. No drama. Then one afternoon, a white envelope showed up nailed to a tree at the edge of my driveway. Not mailed. Not delivered. Nailed. Across the front, in bold red letters, were the words: Notice of violation. Final warning. Inside was a multi-page document listing violations I'd supposedly committed: unapproved exterior renovations, non-compliant roofing materials, unauthorized structure occupancy. At the bottom, total fine, $30,000. Signed by the HOA board president. I laughed. Out loud. Alone. In the woods. Because the HOA named on that letter governed a subdivision nearly half a mile away, separated from my land by a creek, a tree line, and a very clear jurisdiction boundary on the county map. I assumed it was a mistake. Maybe they confused parcels. Maybe someone new on the board didn't know the area. So, I did the polite thing. I emailed them. I attached my deed, the parcel map, the county zoning letter stating plainly, this property is not subject to any homeowners association. I ended the email with, please confirm this fine has been withdrawn. 2 days later, I got a reply. Not an apology. Not confusion. A threat. The board claimed my cabin was visibly within the HOA's area of influence, and therefore subject to enforcement. They said my refusal to pay would result in legal escalation, liens, and possible removal of non-compliant structures. That's when I realized this wasn't ignorance. It was entitlement. They weren't mistaken. They were testing me. Over the next week, they sent more letters. Certified. Aggressive. Each one increasing the fine with late penalties. Then they posted a notice on their community board announcing enforcement action against an uncooperative property owner. My name. My cabin. Neighbors I'd never met started driving by slowly, taking photos. One woman actually walked onto my land and measured my porch with a tape measure. That was the moment I stopped replying. Instead, I hired a property attorney. Within 48 hours, we had something the HOA clearly never bothered to check. Recorded plats from 1952. Jurisdiction boundaries. Prior court rulings involving the same HOA overreach. And then we found the big one. The HOA had already been warned by the county 3 years earlier for attempting to fine properties outside its authority. They knew better. They did it anyway. So instead of fighting the fine, we did something else. We filed. Not just for harassment. Not just for trespass. But for abuse of authority, fraudulent enforcement, and knowingly issuing illegal fines. And once that filing hit the court docket, everything changed. The tone shifted immediately after the lawsuit was filed. For weeks, the HOA had been loud, confident, and aggressive. Their letters read like commands. Their emails were written as if authority was assumed, not questioned. But once the court clerk stamped our filing and the case number became public record, the noise stopped. No more notices. No more threats. Just silence. That silence lasted exactly 4 days. On the 5th day, my attorney forwarded me an email he'd received directly from the HOA's legal counsel. Not the board president. Not the property manager. A lawyer. And the subject line said everything. Request for informal resolution discussion. Translated, they're nervous. The email claimed the board had been operating under a good faith belief that my property fell within their enforcement zone. They suggested a mutual misunderstanding and proposed that all fines be paused while they re-evaluated jurisdictional boundaries.
Paused.
Not withdrawn.
Paused.
We declined. Instead, We responded with something far more effective: documents. Certified surveys. County GIS overlays. A notarized statement from the zoning office. And a copy of the prior county warning issued to the same HOA for overreach. That last attachment changed everything. Because once it was included, this stopped being a boundary dispute and started looking like pattern misconduct. The HOA's lawyer called the next morning. He was careful with his words. Asked a lot of questions. None of them about the cabin itself. All of them about what remedies we were seeking. That's when my attorney made it very clear. We weren't negotiating fines. We weren't interested in apologies. We wanted the court to decide whether the HOA board knowingly acted outside its authority and whether individual board members could be held personally liable. That word, personally, landed hard. Within hours, the HOA scheduled an emergency board meeting. We know because the agenda was accidentally emailed to the wrong address and forwarded to us by a confused resident. The subject line read, "Urgent, legal exposure discussion." At that meeting, everything unraveled. Some board members claimed they'd been assured the cabin was close enough to enforce. Others admitted they never checked the plats. One openly asked whether board insurance covered intentional acts. Another asked if fines issued illegally could be considered fraud. Meanwhile, the community started asking questions. Residents noticed the sudden halt in enforcement, the missing updates, the closed-door meetings. Someone posted anonymously in the HOA forum asking why dues were being increased to cover legal expenses involving a property we don't own. That post exploded. People demanded explanations, financial transparency, copies of the enforcement authority. And when they pulled the governing documents themselves, they saw the same thing we'd been saying all along. The boundary stopped at the creek. My cabin sat well beyond it. The board tried damage control. They sent out a carefully worded notice claiming the issue was under review and urged residents not to speculate. That only made things worse, because now residents were speculating with documents in hand. By the end of the week, 2 board members resigned. Quietly. No announcement. Just gone from the directory. The remaining members scrambled. They offered to formally withdraw the fine, then to reimburse legal costs, then to reach an amicable settlement if we'd drop the case. We refused every offer, because by then, the case wasn't just about my cabin anymore. It was about what happens when an HOA decides it can extend power simply because no one pushes back. It was about whether boards can invent authority, issue massive fines, and gamble that property owners will just pay to avoid conflict. The court date was set. Discovery was scheduled. And for the first time, the HOA wasn't the one issuing deadlines. They were the ones facing them. The courtroom that morning was calm, but you could feel tension simmering beneath the polished wood and neutral walls. The HOA board members filed in, one by one, visibly pale and whispering to their attorney. They had expected me to cave. They had expected a correction behind closed doors. They did not expect a fully documented, legally airtight case. The hearing began with a review of the property lines. The county plat maps were projected onto a screen. The judge, stoic, precise, pointed to my cabin and the surrounding parcel. "Please confirm," the judge asked, "whether this property is within the jurisdiction of the HOA filing these fines?" Karen, the board president, swallowed hard. She glanced at her attorney, then back at the judge. "No, Your Honor. Technically, it is outside." Her voice trailed off. The attorney jumped in, trying to explain community influence and shared interests. The judge tilted his head, unimpressed. "Community influence does not grant legal authority," he said bluntly. "Ownership, easements, and recorded covenants govern this matter." The HOA's enforcement notices were presented as evidence. Each was read aloud: violations, penalties, threats. My attorney highlighted that each fine violated the recorded jurisdiction limits. He pointed out that the board had previously been cited by the county for attempting similar overreach. "Repeated pattern of knowingly issuing illegal fines," he said, emphasizing the words. You could see the color drain from their faces. Next came testimony from neighbors. Not in anger, not as witnesses to my behavior, but to confirm the geography and boundaries. A retired surveyor explained the historical parcels. A local title agent clarified the recorded easement lines. Each detail supported my case. By the time the testimony concluded, the HOA's influence was exposed as nothing more than overreach and assumption. The turning point came when my attorney asked for the board members to acknowledge personal responsibility for issuing unlawful fines. The courtroom went silent. The attorney explained that if they had continued enforcement knowing the fines were invalid, insurance coverage might not apply, potentially leaving them personally liable. Karen shifted uncomfortably. The other board members avoided eye contact. You could almost feel the weight of accountability pressing down. Then the judge made a motion everyone had been waiting for. The fines issued against the property at address are hereby voided. The board must provide written notice to all affected parties of the lack of jurisdiction and cease any further enforcement immediately. Gasps echoed quietly through the room. The HOA's attorney tried to interject, suggesting a minor procedural review, but the judge waved him off. The ruling was clear. The board had acted outside its authority, and the fines were null. Finally, the judge added a warning. Any future enforcement attempts on properties outside the HOA's recorded jurisdiction will be considered unlawful and may result in personal liability for the board members involved. Karen's shoulders slumped. Her confident posture from before had vanished. The board exchanged awkward glances, and murmurs filled the back of the courtroom. The HOA had assumed power where it didn't exist, and the law had just corrected the record. By the time we left the courtroom, the entire energy had shifted. Neighbors I'd never met approached me with congratulations, a mix of relief and admiration. The road was no longer a potential battleground. It was simply the land I owned. After the court ruling, the HOA entered a phase that no one on the board had anticipated: panic without direction. Their authority, which had once been assumed, was now formally challenged and legally constrained. The first sign came in the form of frantic emails and phone calls among board members, debating how to phrase a public statement without admitting fault. Every message had a tone of fear mixed with disbelief. They had spent years enforcing rules they didn't actually have the right to enforce, and now the consequences were becoming real. Internally, the HOA's meetings became chaotic. The president, Karen, attempted to regain control by proposing new compliance guidelines and insisting that future inspections be carried out with stricter adherence to bylaws. But the attorney kept interrupting, reminding them that any overstep could result in personal liability. The board members realized that if they didn't follow the law to the letter, their own homes and finances could be at risk. For a group used to bullying neighbors with fines, this was humbling. Residents began noticing the change immediately. Notices that once threatened penalties were replaced with polite reminders, phrased as suggestions rather than mandates. The fines were officially rescinded, and any talk of backdated penalties vanished. Community discussions shifted from compliance enforcement to actual problem-solving. Requests for road maintenance, previously ignored, were finally addressed, but in accordance with real agreements, not arbitrary decrees. People were shocked to realize how much of the HOA's prior authority had been based on assumption rather than legality. The board tried damage control with the broader community. They held a meeting and publicly acknowledged that fines issued against my cabin were unauthorized and void. They explained that they had misunderstood the jurisdiction. Some residents were skeptical, others relieved, but the room was quieter than expected. Karen's defensive tone was gone, replaced by cautious explanations. The once confident, aggressive leader had learned that perceived authority means nothing without legal backing. Financially, the HOA faced immediate consequences. Funds they had relied on from illegal fines were now gone. The treasurer presented revised budgets, showing that the fines had been a significant part of projected income. Projects would need to be funded directly from member contributions, and any mismanagement could no longer be hidden behind enforcement income. The mood shifted from anger at me to realization of their own mismanagement. Even outside the financials, the cultural impact was evident. Board members became careful, deliberate, and increasingly transparent. Every enforcement action required documentation, approvals, and legal verification. The aggressive posture that had once defined the HOA was replaced by cautious compliance. Neighborhood discussions, once dominated by fear of fines, became practical conversations about upkeep, shared spaces, and community events. For the first time, the HOA wasn't a source of stress for residents. It became a functional administrative body. Meetings were shorter, communication was clearer, and disputes were resolved through discussion rather than threats. Karen's resignation eventually followed quietly. She had become a symbol of overreach that the community no longer trusted. A new, more methodical leadership team took over, and the neighborhood slowly began to regain its calm. And for me, I didn't need to participate actively. Ownership of the cabin and the clear legal boundaries ensured that my land and my peace remained secure. The HOA had learned, painfully and publicly, that authority only exists where it is granted, and that overreach comes with real consequences. With Karen gone and the board reorganized, the HOA finally entered a period of stability, but stability born from accountability, not fear. The moment the court ruling became official, the fines against my cabin were permanently voided, and the board members were reminded that any future attempt to enforce rules beyond their jurisdiction could result in personal liability. That warning hung over their heads like a cautionary cloud, influencing every decision they made afterward. Residents, once anxious about overreach, began engaging constructively. Questions that previously would have resulted in fines or threats were now answered with clear references to bylaws, county maps, and recorded easements. The neighborhood discovered a new rhythm: cooperation instead of confrontation. Road maintenance schedules were agreed upon and adhered to without dispute. Shared spaces were discussed logically rather than policed aggressively. Fear had been replaced with clarity. For me, the change was subtle but profound. My cabin, once a target of harassment, was now treated with respect. The HOA no longer sent letters, nor did they appear on my property to inspect or measure. Neighbors who had witnessed the board's overreach expressed quiet relief and appreciation. It wasn't about vindication anymore. It was about boundaries being acknowledged. Ownership and legality, not fear, had established peace. The broader lesson rippled beyond my parcel. Other property owners in neighboring areas began reviewing their own HOA agreements, questioning which fines and enforcement actions were legitimate. Some discovered similar overreach and filed complaints or lawsuits of their own. The story spread quietly. An HOA had been held accountable, and it sent a clear message: overstepping authority has consequences. The HOA itself became a case study in internal reform. Meetings became methodical. Every action required documentation and legal verification. Aggressive tactics were replaced by procedural accuracy. Karen's absence left space for a leadership team that understood the limits of their power and the importance of adherence to both bylaws and property law. The community, once wary, began to trust its governing body, not because of fear of fines, but because the board followed the law. As the seasons changed, I walked my cabin property, gravel path underfoot, chimney smoke curling into the air. Everything was as it should be. My land untouched, my home respected, and the boundaries of authority firmly established. No letters, no threats, no fines. The HOA had learned that their attempts to control what wasn't theirs could not succeed, and in the process, they had inadvertently taught the neighborhood a lesson about limits, legality, and accountability. The $30,000 fine that had once threatened to disrupt my life became a cautionary tale. Not for me, not for my cabin, but for every board member who might think they can extend power beyond what is granted. Authority is not a given. It is defined, recorded, and legally bound. When that line is crossed, consequences follow. And in this case, the law ensured that the lesson was unforgettable. Peace returned, boundaries respected, and the cabin, my sanctuary, remained mine, free from unlawful interference. The HOA would never again assume power over property that wasn't theirs, and the neighborhood, wiser and calmer, settled into a newfound order.